This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as a insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to speak about the basics of third-party liability claims adjusting. The insurance adjuster is seldom, if ever, mentioned in a policy of insurance. The strict wording of the third-party liability policies set the obligation to prove a claim that entitles the insured to defense or indemnity of a claim against the insured by an injured third party. Over a century ago, insurers determined that to properly deal fairly and in good faith with their insureds, an insurance claims professional was needed to thoroughly investigate claims made against the insured, work with the insured and a third-party claimant to resolve claims without litigation, and properly protect the interests of the person insured. Adjusting liability insurance claims requires skill, patience, knowledge of insurance, basic knowledge of tort and contract law, and knowledge and experience as an investigator. To properly and effectively perform the duties of a liability claims adjuster, he or she must be capable of effectively dealing with the following basic obligations. 1. To understand the law of torts as applied in the state where the adjuster works. 2. To understand the law of contracts as applied in the state where the adjuster works. 3. To understand sufficient medical terminology to be able to evaluate claims of injury. 4. To understand the cost to repair or replace damaged real or personal property. 5. To understand how to read and apply the terms and conditions of a liability insurance policy to a particular fact situation developed by his or her investigation. 6. To understand how to thoroughly investigate all claims assigned. 7. To conduct an investigation of every claim assigned fairly and in good faith, with an intent to find coverage for the loss presented by the insured. 8. To be able to effectively, fairly, and in good faith negotiate with claimants and lawyers to resolve bodily injury or property damage claims assessed against an insured. 9. To ascertain that the insurer pays promptly all claims the insurer owes under the contract, and 10. To resist and recommend against payment of all claims the insurer does not owe under the contract of insurance. Unfortunately, in the United States presently, the average adjuster is a 22-year-old graduate of a liberal arts college who has little or no training sufficient to allow him or her to fulfill the obligations imposed on them as a representative of an insurer. Much to the chagrin of insurance claims professionals, some modern insurance companies are willing to give the title adjuster or claims representative to a recent college graduate who has no education or training in insurance, tort law, contract law, investigation, claims handling, or negotiation. These insurers, unconcerned with the need for an insurance claims professional, simply hire a person to be an adjuster, provide no training, and send them out to deal with the public with only the assistance of a claims supervisor who may only have 2 years of experience himself or herself. The liability claims adjuster must quickly learn that there is little difficulty with a claimant the person alleging bodily injury or property damage against a person insured if the claim is paid as demanded. The insured may be unhappy if the claimant's claim is paid as presented, since most do not believe they did anything wrong or fear an increase in premiums charged for subsequent policies. Of course, holding a claimant down to what he or she asks for is not adjusting. Rather, it is simply acceptance of an extortioner's demand, which may or may not be reasonable. The adjuster must be prepared and able to show empathy but not sympathy while professionally investigating a liability claim. In addition, the adjuster must be able to salve the emotions of the claimant and the insured, explain why in the law and the policy it was appropriate to pay or not pay the claimant, and that a settlement is in the best interest of both the insured, the insurer, and the claimant. The adjuster should know and must be prepared to explain to an insured that if a claim is resisted or denied, the claimant will be unhappy and will probably file suit. If not promptly settled, the claimant's lawyers may work to rake the insured over the coals to prove that the insured is liable for a claimant's injuries. The adjuster need also explain that the insurer will retain experienced defense lawyers to protect the insured from the actions of the claimant's lawyer. The adjuster is also obligated to explain clearly and with empathy the needs of the insured, his or her obligation to expend time and effort to establish all defenses available to the insured, determine the extent of the claimant's injuries and who is responsible for the injuries, and whether comparative negligence will limit the extent of the insured's liability to a third party. Failure to settle promptly can cost the insured his or her reputation, his or her time in deposition and assisting defense counsel, cost the insured's time if the case goes to trial that the insured will be required to attend, and will certainly cost the insurer much more than the claim could have been resolved had it been resolved before the claimant retained a lawyer. The adjuster must also understand that investigation may establish that the insured is not responsible for the injuries claimed. In such a situation, settlement is not called for because of facts generated at the investigation of the loss and claim. If the investigation results in a conclusion that the insured is not liable to the third party, the adjuster must be able to explain to the insured and the claimant why the claim may not be settled. Since most people would prefer not to be deposed by a claimant's lawyer, nor would they want to be cross-examined during a trial, it is the duty of the adjuster to explain to the insured's responsibility to assist in the defense of what will become an eventual lawsuit if the claim is rejected, and that every policy of insurance contains a condition requiring the insured to cooperate with the insurer in presenting a defense to any litigation or claim. The duty to settle is not unlimited. It is also the obligation of the adjuster to prevent a claimant taking advantage of the insured and the insured's insurer when investigation establishes that the insured is not responsible for the injuries claimed. The liability adjuster must also be knowledgeable of the fact that many liability claims are part of fraudulent schemes that are used by the unscrupulous to profit from fake accidents and injuries. The best estimates that the insurance industry has established is that insurance fraud takes more than $80 billion and up to $300 billion a year from the insurance industry. Most of those less than legitimate claims are paid because of one or more of the following happenstances. The adjuster is untrained. The adjuster was minimally trained. The adjuster was either unable or unwilling to perform a thorough investigation. The adjuster was so inexperienced that he or she did not know how to investigate. The adjuster was unable to read a policy with comprehension because he or she had not been trained, he or she had been trained inadequately, or he or she had no legal training and did not know the rules of contract interpretation. The fraud perpetrator is intelligent, not greedy, and knowledgeable about the law of negligence and how claims people adjust and resolve liability claims. The insurer does not want to fight because legal costs to fight a fraud exceed the settlement offer made by the claimant. The adjuster does not recognize the indicators of fraud. The adjuster is more concerned with closing his or her files than dealing with a potential fraud. The adjuster recognizes the indicators of fraud but refuses to refer the claim to the insurer's special investigative unit. The police authorities refuse to investigate, let alone prosecute, insurance fraud. A thorough investigation of a claim must complete all of the duties the adjuster owes to the insured and the insurer. A thorough liability claims investigation allows the insurer by the adjuster to keep all of the promises made by the policy. The liability claims investigation should never be limited to giving a blank check to claimants. The adjuster's obligation is to deal fairly and in good faith with the insured, the claimant, and the insurer. And how does the adjuster do this? First and foremost, to become a professional liability claims adjuster, the adjuster must be able to read the policy, establish that coverage exists, meet with the insured and all witnesses, obtain a thorough recorded statement from the insured and all witnesses, obtain a report from the relevant governmental agencies, obtain relevant documents from the insured and the claimant, and establish the amount of the loss and claim for property damage by determining a thorough scope of loss and using the assistance of a construction consultant. And for bodily injury claims, the adjuster must determine the extent of injuries and treatments. This video was adapted from my book, The Compact Book of Adjusting Liability Insurance Claims, 3rd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful or of interest to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and blog postings. Thank you for your attention.